G'day everyone, this is the third and final video in week 10 of our admin law course. This week we've been looking at freedom of information, the question of how and when people can get their hands on government information. We've learned that the FOI Act and its Queensland equivalent represented a revolution in administrative law because they flipped the presumption about secrecy of information. Instead of presuming that government information was secret, as a result of this legislation, we presume that government information is public. It's public information unless an exemption applies. In this video, we're going to look at those exemptions. Now, it's inevitable that when people think about exemptions, they straight away think about how those exemptions might be abused, how they might become havens for government secrecy. And that is something to keep an eye on. But in reality, many of these exemptions really are based on justice. You don't want any old person to get access to your health records. We don't want DV perpetrators getting access to police files containing their victim's current address. Everything is about balancing the public interest in the freedom of information against the legitimate interest, public or private, the legitimate interest in keeping that information under wraps. There are a range of exemptions to freedom of information. The first one, and one of the more problematic ones, is national security. Section 33 of the FOI Act exempts documents which would reasonably be expected to cause damage to the security of the Commonwealth, the defence of the Commonwealth, or the international relations of the Commonwealth. Now, on the one hand, this makes sense. We don't want adversaries in other countries getting access to our defence secrets. I don't think there'd be too many arguments there. The problem occurs when the concept of national security is overlaid with the concept of the government's security. If something awful happens in defence, the government shouldn't be able to suppress it just because it involves defence in order to prevent the government from being embarrassed. It has to be the sort of thing that would cause damage to Australia and not just to the Prime Minister or his or her party who happen to be running Australia at the moment. The second exemption is cabinet documents. Section 34 of the FOI Act makes cabinet documents exempt from FOI. Now, without turning this video into a political science lecture, the Cabinet is a weekly meeting of the Prime Minister and all of the more senior ministers. Cabinet is governed by a Westminster doctrine called collective responsibility, which means they can argue like cats and dogs behind closed doors. But once the collective decision is made, they all go out in public and support it. To enable this, the records of Cabinet are locked away for, depending on where you are, either 20 or 30 years, and then they are released, usually on the 1st of January each year. The third exemption, found in Section 37 of the FOI Act, is law enforcement. This one really does make sense. Imagine if a criminal who knew that they were a suspect in an investigation could make an FOI request for the detective's notebook, or if they could find out the identity of the person who dobbed them in. I think most people would agree that this exemption is just common sense. The fourth exemption found in Section 38 is secrecy. This overlaps a lot with the national security exemption, but they're different. Access to a document can be denied on national security grounds just because the decision maker forms the view that national security is in peril. There's no need for legislation. However, some pieces of legislation specifically make things secret. They specifically impose a requirement of secrecy. In that case, the FOI Act loses out and the materials remain secret. But at least the legislation is telling us what's being kept secret. The fifth exemption, found in Section 42, relates to legal professional privilege. Like any other person or organisation, the Commonwealth sometimes sues and it's sometimes sued. And the Commonwealth engages lawyers to act on its behalf. And the Commonwealth has confidential discussions with those lawyers. It stands to reason that those lawyers owe the duty of legal professional privilege to the Commonwealth, and the Commonwealth should be able to keep its legal advice to itself. It'd be quite unusual, for instance, if a party was involved in litigation against the Commonwealth but during that litigation, they were able to make an FOI claim to see what the Commonwealth's legal strategy was. The sixth exception is found in two places, in section 45 and 47. Section 45 specifically relates to confidential information where equity law creates a duty of confidentiality. Section 47 focuses on commercial and trade secrets. The combination of these provisions means that the Commonwealth is entitled to protect the commercial confidence of any company that it's doing business with. Again, this makes an awful lot of sense. Imagine if there was a tender process and every company involved in the tender process could use FOI to get access to the tenders put in by all their competitors. No commercial agency would ever provide services to the government under those circumstances. Next, we have parliamentary privilege and court privilege. This exception is found in sections 45(a) and 46. When a person is speaking in Parliament, and that includes giving evidence before a parliamentary committee, or when a person is giving evidence in court, they cannot be sued or otherwise attacked legally for what they say. The idea is to preserve freedom of speech in our Parliament and our courts. Most of the time, the Parliament and the courts meet in public, and so things that are said in Parliament or in court are typically on the public record. However, the courts and the Parliament are entitled to conduct their proceedings in camera or in secret if the circumstances make it necessary. For instance, virtually all domestic violence proceedings are held in a closed court. In some proceedings, witnesses or parties are given anonymity and their names are recorded either by using a pseudonym or a random set of letters. We've seen plenty of those in the immigration cases that we've come across in administrative law. If the Parliament or the court decides to conduct proceedings in private, then the institution's privileges extend to that privacy. And this makes sense. We don't want people to be able to FOI the details of proceedings or the true identities of participants when the court or the Parliament has already decided that secrecy is in the public interest. We've got just 3 to go. Next, section 47(a) specifically relates to the Electoral Roll. Under Australian law, every citizen over the age of 18 is required to enrol to vote, and the Electoral Roll contains their name, their date of birth and their address. There are some good reasons to keep these things secret, particularly, for instance, in circumstances where someone might have changed their address as a result of becoming a victim of domestic violence. However, you can access your own details on the Electoral Act. The next one is a really big one. This relates to privacy. We've already run into the Privacy Act this week, and privacy law is its own entirely separate area of law. I don't have a hope of being able to really give you any guidance about the Privacy Act in this video. However, in the most general terms, the Privacy Act establishes a set of privacy principles, which bind government agencies and many private enterprises too. The Act sets out rules for how an agency can obtain information from you, how they must store that information, how they can use the information, whether they can share the information, and how they must dispose of the information. The underlying objective is to ensure that people's private information remains within their control, that it can only be collected with their consent, that it will be stored securely, that it'll only be used in the ways described at the time the materials were obtained, that you can have access to your own information, and that it'll be properly disposed of. Now, obviously, it makes sense that if the Privacy Act tells an agency to keep certain personal information private, the FOI Act takes a step back. You can't use FOI to obtain information that's protected under the Privacy Act, and thank goodness. The last exception is very contentious. Documents can be excluded from FOI if there is a greater public interest in keeping those documents confidential. The agency has to balance the public interest in releasing the document and the public interest in not releasing the document. This is really problematic because in the worst case, This could basically function like a get out of jail free card for the department. They've tried to put some boundaries around the public interest exemption. So sections 43B through to 43J talk about some of the considerations that might legitimately give rise to the exemption. But even those are pretty broad. For instance, under the economic public interest exemption, information might not be released if its release would influence the decisions or actions of a person. Now that's pretty darn broad. All we can really do is hope that the journalists and the oppositions are really holding a blowtorch to the government to ensure that these exemptions are used properly. So, what have we learned this week? Well, first, at a basic level, we've learned that administrative law relies to a great extent on the ability of normal people to obtain access to the information held by government. If the government is entitled to keep its information secret, much of the rest of administrative law falls apart. It results in corrupt governments which are immune from outside scrutiny. And so we have the Freedom of Information Act and its state counterparts. We have information provisions in specific pieces of legislation, and we have the ability under the FOI Act to obtain a statement of reasons for a decision. This freedom of information, however, is subject to a range of exceptions, some of which are sheer common sense and some of which are more contentious. Those arise from the FOI Act itself, from the Privacy Act, and from other legislation which touches on secrecy. The exceptions are acceptable, even necessary, when they protect the interests of the public or when they protect individual privacy. However, there is always the danger of those exceptions being twisted so that they're used not for the benefit of the public, but in order to avoid public scrutiny. One way to avoid government abuse of power would be to have certain people who are public servants and who therefore have access to all of the government's information, but whose role exists outside the normal public service, so they can look in and scrutinise. Our system of government has developed such an office. They are called the Ombudsman, and we'll look at them next week. See you there.